Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 169 of the NCDWI Guy podcast. On today's episode, I have Lindsey Granados coming on to talk with us about the current state of eCourts in North Carolina. This is an extremely important episode because this is something that is going to fundamentally change the practice of law for everyone in the state, but certainly for criminal defense lawyers. If you're in one of the 4 pilot counties where this has been launched, you're already dealing with this. But Lindsey gives a ton of information about eCourts, and I would say more importantly, in the vast majority of counties where this has not yet been implemented, some ideas for trying to get ready for this coming down the pike. It has really been a challenge, a struggle for lawyers practicing criminal defense in the 4 pilot counties, and everyday frustration. Things that used to take, a few minutes are now taking hours of time. There is kind of a poor kind of circuit of information in terms of once you file something through eCourts, knowing how, when that's actually been received by the DA's office or judge, whoever needs to actually be looking at the motion. It's just got a lot of inefficiencies that Lindsey will talk about. And so getting ready for this in your practice is going to be huge. I had the recent privilege of meeting Lindsey at the North Carolina Advocates for Justice Convention in Charlotte, and really enjoyed meeting Lindsey in person. Lindsey has kind of been like the attorney that has been thrust into the forefront on this issue. She practices primarily in Wake County. She currently serves as the president of the Wake County Academy of Trial Lawyers. I think she's the current vice president of the Wake Women Attorneys. She has been very much front and center in terms of legal leadership on the eCourts side of things here. Recently on the North Carolina Advocates for Justice listserv. So if you're a member of the listserv, you're probably seeing those updates that Lindsey is sending out. If you're not a member of the listserv, then you should be, because it's a great way to improve your practice. Lindsey's firm handles traffic, criminal, DWI defense. She has tried hundreds of district court cases, infractions, misdemeanors of every variety, and DWIs. She's taken numerous high-level felony cases to trial in Superior Court. She's a former DA, and I think that actually gives her a unique perspective in terms of the challenges that the ADAs are facing when it comes to eCourts. But again, Lindsey has really been leading the charge on this, as she has mentioned in her updates and on our call today. This has created an enormous burden in terms of her and other lawyers who are dealing with eCourts on their practice. So I'm very grateful for her to take the time to talk to us today, but she has been putting a lot of time and energy, not only into changing eCourts for the better in Wake County, which will impact the rest of us, but by keeping us as a defense bar updated on this issue. And somehow through all of these additional frustrations and struggles that Lindsey has dealt with on this front, she has maintained a really positive attitude about this, and really I think, kept her mind in the right place in terms of trying to implement changes in this system, as opposed to just by frustration throwing in the towel. So we're going to actually talk a little bit about Lindsey's mindset, because I really do think it's helpful as we all are getting ready to kind of move into this place of struggle. But without further ado, Lindsey Granados, I hope you enjoy all of her updates and advice. Lindsey, it's awesome having you on the show. I'm sorry I got us off to a delayed start here. My sincere apologies on that front. Thanks for bearing with me. But really a pleasure meeting you at the North Carolina Advocates for Justice Convention. First time that we had kind of met in person, and I really enjoyed talking with you. And you have been such a leader on the eCourts front, kind of keeping everybody appraised. I don't think that was a delegation you sought to like take on, but somehow you've become the kind of go-to person in terms of information on the eCourts end of things. So I guess I think what would be really the most helpful for everybody listening is to just kind of get a big picture of eCourts, where it stands, kind of the big overview. Everybody that's in, these 4 pilot counties, they are kind of in the throes of it. But I think for most of us outside of that, there's, we get some messages every once in a while from AOC or from, somebody at the local level, giving an update. But it's very much a black box in terms of, how it's gone, problem points, where it is currently, what the next steps are. So wherever you kind of think the best or worst place to start is, I'll kind of just put that in your court.
So as a kind of an initial thought on where we are right now, we went live in the pilot counties on February the 13th of this year. So we've been at it basically for 5 months at this point. It has been a very, very rough start from our perspective. And I can't underscore how wholeheartedly this has completely changed the practice of law for us. That is the big takeaway that I really want, everybody to understand, is this is not just a minor, little change, little tweaks here and there. This is a completely mindset shifting practice. Like there is literally no way I can underscore enough how much this has changed our practice internally, and how we're still having to continue to try to evolve to keep up with the changes that are coming down. One thing that, you bring up, like, the rest of the state, I know that it's been, we're kind of smack in the middle of it right now for the 4 pilot counties, but I know there's a great deal of uncertainty for the remaining 96 counties in North Carolina in terms of when it gets to them, and when it does get to them, how is it going to look, when they get there. I think that it will be, just by definition, it will be better for when it does get to you. However, that doesn't mean that this is a great program. That doesn't mean that this is a wonderful change for the practice of law as we know it. That's not the message I want to convey. It is wholeheartedly very much a sluggish type of program that creates delays and creates a lot of problems right now. And I think that some of those are being worked out, but I think that we're getting close to where we would be at what I would describe as peak efficiency. In Wake County, the DAs know how to operate the system. The clerks know how to operate the system. The judges know how to operate the systems. The fact is, though, that there is only so fast and so many things that they can do that that makes it to where it's just they can't do it all at the same time like we used to, and at the same speed that we used to. So realistically, the biggest change that we've seen is that it basically takes about 5 times as long to do anything as it used to. Even a simple matter of like walking into traffic court with the shuck, and you've got the shuck in hand, you hand the shuck to the DA. The DA is like, okay, I'll reduce this down to whatever. Cool. Then you hand it up to the judge and you're over and done with in a couple of minutes. It doesn't take that long. Now, You have to go in there. The DA has to find your client, which sometimes they can't do in the system. Then they have to pull the client up. They have to amend the citation, and it takes longer than just simply, writing on a shock. And then they have to send it in a queue to the clerk, who then sends it to the judge. And then finally, you get to enter your plea in court. And it's just the time that it takes is just literally like you could used to be able to be done in like 2 minutes on like one case. Now it will easily take 5 to 7 to 10 minutes just to be done with one thing.
Yeah, district court has always been this kind of like orchestra of efficiency. I mean, when you walk into a district courtroom, you can tell the DAs that know how to move cases and the judges that are kind of like good at kind of directing things to kind of be moved along the pipeline, because there's just so many things that are on. If you're not kind of hitting, really quickly everything that needs to get done for the day, you can run into a lot of problems where, the docket just does not get handled. And so any cause for inefficiency is a real issue. And I think, it sounds like to me beyond that, it is so hard to get a DA's attention or a judge's attention. Everybody is vying for that. Without eCourts, you walk into the courtroom, there's 10 defense attorneys waiting to talk to the DA, victims, everybody that is on, in the courtroom that has their name called has to talk to the DA. So there's all of these people that are vying for the DA's attention. And so now if you've got something to present to the DA, but they're like, well, I'll look at it in eCourts when I get there. That just seems like such a, massive problem in terms of being able to like get the DA's attention. And, I know how, easy it is to let something sit in an inbox for, an afternoon, a day, a week. It's easy to not respond to things that are like kind of not right in front of you. And so because all of these documents that are moving through eCourts really are, there's no person. It's just like I'm assuming more of like file number and like, name of document, which may or may not be accurate. It just seems like it's going to be a real problem in terms of getting attention. So just from like a practical standpoint, is that an issue? And if so, what do you have any kind of like tips for, the proper ordering of conversation with, DA or judge about something that's on the calendar and like, here's where this is, or I know it's seemingly like hard to like track down some of these documents. So don't know if you have any kind of like thoughts or practice tips on that front.
I would say right now, the thing that frustrates most attorneys the greatest amount at right now and where we're at is the fact that once you hit the button and you file whatever it is that you're trying to file, whether it's a motion to strike call and failed, or whether it's a motion to continue before the court date, or whatever it is that you're filing, motion for appropriate relief. Once you hit send, okay, you hit, confirm, and you file that into the eFile and serve system, it's out of your hands, it's out of your control. And right now, one of the biggest issues still with the software that has not been resolved is the fact that there is a functionality within the software that allows for back-end notifications for attorneys who have filed into a case, filed notice of appearance in the case. If anything gets filed in that case, there is a functionality that, similar to the federal system, if you're familiar with PACER, or CMECF, whenever you file something into the case, anytime anybody does that, you get a notification and a link directly to the case and where it's stored online. Right now, that functionality is not turned on. And so we are constantly having to revisit and recheck over and over and over again to see if things have been uploaded to the portal, and trying to get the DA's attention on something that you have filed that's just been hanging out there in the wind for X number of days or whatever has become a real issue. To be honest, like, everybody in the system right now is completely overworked, is over capacity, is, beyond stressed. That includes DAs, PDs, defense attorneys, clerks, judges. We are all stretched beyond what we should be handling. That is 100% without a doubt. And you brought up the point of like how the small inefficiencies can add up over time. And, we're definitely already starting to see that play out in the courtroom. Statistically speaking, I was in one of our implementation meetings a couple of weeks ago, and they were talking about the numbers specifically of how many cases we're disposing of relative to new filings that are coming in during the same time frame. And the general consensus on the ground before we had these numbers was that we were probably only able to dispose of about 60 to 70% of what we were able to handle in a session of court. We're not able to get to the rest, so the rest just gets continued. The numbers came out and they showed that, for year over year, last year to this year, we disposed of 65% of the cases that we did last year at the same time last year. So clearly there's a 35%, group that people that are in the 35% are just getting kicked down the road. And it's going to be something that is going to continue to add to the district court backlog. And we're struggling with that. I mean, already in a very high volume county like Wake, we have, there's just a crushing onslaught of new cases that are coming in. And, we've been able to manage, but I would say that there's going to come a point when it's going to be a real problem. And we're starting to see the signs of that. But there's just like, when courts shut down for 2 years for COVID, or for a full year, and we're still doing the catch up from all the trial backlog, we're still going to be doing that, but we're now dealing with that in district court. And that's going to be something that's going to be a real, getting your case to trial is going to be even longer than it has been. So these factors have to be taken into account by attorneys that are trying to figure out what are their services worth in the marketplace right now? What does it cost to take care of a case? What's the overall, analysis you have to engage in when setting appropriate fees for that? Because everything is taking longer.
Yeah. And I bet that number actually kind of understates the problem in terms of that capacity, because anything that's not on the docket, like you were just talking about, motion for appropriate relief, any of like the extra stuff, I'm sure is getting like buried at the bottom of the bottom of the bucket. Like that's like, hey, this person isn't on today. We are not going to worry about that right now.
Yeah, that's definitely the case. The DAs are focused on what they have in the courtroom. And as I'm sure most places across the state are similar, their DAs don't really, we have calendar at 9 and 2 in Wake County. So our DAs are constantly in court. They rarely get time out of court. So trying to follow up with the DA is in their off hours, and getting them to actually call you back right now is almost non-existent. Getting them to respond to emails is hard enough. And now that's becoming even harder. They're just overwhelmed and overworked.
Yeah. I mean, I think that lack of efficiency is just, so draining for anybody that's involved in that space. You had said a couple minutes ago, the, functionality in terms of kind of being able to track a document that you have submitted for consideration of the state or the court. You really can't track that. Is that a tool that exists and it's just not turned on, or that just does not exist in the software, period?
It does not exist in the software, period. I mean, ultimately, if somebody files something into the case, once they get this fixed, this functionality fixed, we will get notifications for if a judge signs the order, right? So that's an important thing
Yes,
that
that
we're
would
not
be.
getting notified about right now. I hope that should hopefully change by the end of this year, which is
Okay.
the goal. But as far as like, when things get sent out there, you have to constantly stay on them. And we have so many things we're dealing with in the course of a day that, to have to go and recheck up on your work, 4, 5, 6 times because you're not getting notified about it. You can't figure out where it's at. You can't see into the system. So like, this is one thing that maybe a good explanation of like what it is, the computer systems that exist might be a good opportunity, I guess, to talk about that. So initially, the court system that the clerks are using is Odyssey. Okay, everybody knows that name now. Odyssey is the clerk computer system. That is the court of record. That is the where all the documents are housed. That's where everything is internally done. There are several other aspects to the Tyler Tech software that are utilized by different parties. So, for example, the defense bar, what we are using is eFile and serve in conjunction with Portal. So Portal is where you can go to view all of the documents on the web. Okay. And that is where, like, if you have a file number, you can click in your file number. Hopefully it will come up. It hasn't always been the case. And it's still kind of hit or miss, in my opinion, in terms of how much you can actually see in Portal. And being able to find your cases can be a real tough thing, especially if you're doing like a name search and you don't know a case number yet. But you've got the portal that you're viewing the case info on. Ideally, in like the optimal scenario, you will have the ability to click on the documents that have been filed directly into that case, and it will open it up in a PDF format that you can see and view that. So you can view things like charging documents, conditions of release. You should be able to view like any motions you filed. You should be able to view like, anything that pertains to the case that has an event, that has a document that you would ordinarily be used to seeing. It would be there. There are different functionalities within eFile and serve, which is what we use as the defense bar to file into Odyssey. So when we are, and I would go ahead and tell everybody, go ahead and right now, before things get too far down the road, go ahead and create your account in eFile and serve. Go ahead and create an account in Portal so that you can log in and view documents. Go ahead and submit a request for an elevated access. These are things that you can do now to go ahead and try to like poke around under the hood.
That's great advice.
And see exactly like how to go in and utilize the system. So that way, I mean, because when we went live on day one, we didn't know anything about this. we just had to come in and like figure it out for ourselves, basically. And so I would suggest that you can, because it's live, because before it went live, there was no test world that we could really go in and play around in. But now you can actually go in and you can see in the 4 pilot counties, just look around, see what you can figure out, and go ahead and get your account set up. So eFile and serve is what we use to actually file into Odyssey. That's where you will upload, similar to Pacer, you will upload PDF documents into your specific case to file into the case. And you can see your filing history. Once you file into a case, you get 2 emails from the clerk's office. You get the first one, which is the notice of submission, and then you'll get the acceptance email. So when the clerk's office has accepted it, that will come in. Now, we've also encountered in the last few months that sometimes documents aren't accepted. And so you have to go back in and try to figure out, why is this document not being accepted? Why is this submission failing? And I literally just had this happen to me earlier this week and couldn't for the life of me figure out why it failed. So those are fun little things that you can, I can see if maybe, and I think maybe this would be a good thing to talk about, like in your local bars, is like if there is a test portal world that you can go in to try and like mess around in and see stuff without actually like having to impact real cases. But maybe that's something that you and your local bars can request access to from AOC and Tyler, who can allow certain folks in. They kept a very close lid on that for the pilot counties because they didn't, to be quite frank, I don't think it was ready. And so they didn't want more people, getting into it and finding, oh, well, this is not exactly what we thought it was
slowing down,
and here's
the
all
process.
these issues, right? And it was also very slow. And so that's the other thing too that you'll notice compared to like when you're used to searching in the AOC, like you go and you do the name search, you just type in last name, comma, first name, no space, and you're good, right? Like boom, everything pops up that's under that name. That's not the case anymore. The searches in portal are somewhat more difficult to do. And ultimately it's just best to go in and just try to like poke around and see what you can find to learn the system before it gets to you.
Yeah, that makes total sense. Once you put a document into the portal, let's just use like a motion to continue as an example. How does it get from like the clerk's office to, does that go from the clerk's office to the DA to see if there's an objection and then go to a specific judge, or and like how does that get to like a specific DA and a specific judge?
I'm going to give you the lawyer answer. It depends. It depends on the rights and roles that have been assigned within the system specifically. But typically the process that it would follow is once you submit it and file and serve, it will go to the clerk's office and it will wind up in a queue, a virtual queue. And the clerk's office is furiously trying to work these queues down to make sure that they're staying current on them. And they are taking action on everything.
Like, I mean, this is like from a phone perspective of like you call the charter company or whatever it is that you're talking to, and you get into the queue and it's, the calls will be answered in the order that they were received. Is that kind of how it works, or is there priority given to certain documents that are on, closer in time, case that's closer in time? Do you have any sense of how that's ordered?
No, I would say that there has been discussion about having higher priority queues for certain types of documents.
Okay.
So for example, like motions to strike, call and failed, and, motions to continue, things like that. There's been questions about having that go into a higher priority queue. But as far as I'm aware, they have not created any of those queues. Okay. So the clerk's office is just like constantly trying to work to keep these things down and keep things moving, when that's because there are things that are time sensitive that create problems if they're not actioned on immediately.
And I guess to that point, in terms of like practical tip, is that something then that you would say is, I mean, there are certain things that you literally just can't file until, day of, or you just don't get the document from the client in time, whatever it might be. But if you're potentially going to be requesting a limited privilege 5 days down the road, or you're going to be doing a motion to continue that a week in advance, would you say that it's beneficial then to like file that as early as possible, just so that it has the highest likelihood of getting seen? Because I can imagine that there's some of these things that are probably not even getting seen before they need to be decided.
Yeah, that's definitely been an issue that, in fact, this last week, I've had 3 specific issues that have come up that have been, I've literally had to send emails to our resident chief district court judge because, these are time sensitive things. Like, for example, I had an LDP where DMV said, oh, well, she's not going to get credit for this. So I had to fill out a different LDP for her so she can get credit on the interlock, right? And that is something that I submitted it as soon as I could in eFile and serve. And then from where it goes at that point and how long it sits in the DA's office, can't tell you. How long then it takes to get to the judge's office, can't tell you. It's one of those things like once you hit that submit button, it is out of your hands. You can try to track it down virtually, but there is no way to see into the system to see where your document is at any given point in time to say, oh, wow, I see it at the DA's office and it sat there for 3 days. I really need to call this particular DA to be like, hey, can you just please help me out with this? That's been one of the biggest frustration and one of the bigger frustrations that defense attorneys that I myself have had just in terms of the implementation of the system. And that's where things that used to take, 15 minutes. If I needed to do like start to finish, motion to strike, call and fill. Wake County, we have this little, piece of paper template that we use, and we just fill in this, fill in the stuff. Then we would walk up to the DA, get the DA to sign it, and then from there, if we got a favorable judge in the courtroom, we'll hand it up to that judge, or we'll walk down to a different courtroom, whatever you want to do, to try and get that thing moving and try to get them to sign off on it as quickly as possible. And then you walk your butt down to the clerk's office, you clock it in, and you're done, right? So all said and done, that takes like 15 minutes. Now it can take days before you get a response back on anything, because this system is designed to keep us out as defense attorneys. It is designed to make us ineffective at our jobs and to minimize our ability to impact the system. That is the crucial key factor about this whole thing and the problems that we're experiencing. And, one of the other issues that I have been, talking on about ad nauseum, and I swear, like in the meetings, people look at me like I have horns because I keep saying, I think this is the way that the system is set up is, I believe there are improper ex parte communications taking place, because ultimately I can't see what the DA types into the system that gets sent directly to the judge. I'm not being provided a copy of that. I can't see that. I have reached out to the state bar and asked them asked them to weigh in on the ethics of this, and I have not received a response back. I have reached out multiple times to try to get them to take any sort of position, and the only thing I've been able to have heard back from them is, we're taking this under advisement, but that was months ago. And this is something I have been raising for months now, is the issue of what I believe are ex parte communications that are taking place every single day. And am I saying that, our DAs and our judges are inherently untrustworthy? No, I'm not saying that. Do I think that most of them are trying to do what they're capable, they're trying to do the right thing under the best circumstances that we have? But the reality is that the system is designed to keep us out, and it is designed to give us less access than we have ever had before. And that is impacting our clients in a very negative manner.
Yeah, I think that's super serious. I mean, if you have a situation where you've got a client that, has an order for arrest, and, whether it was an error or, it's an old case, and you're hired to get that, stricken, if you don't, know when and if that actually gets taken care of, I mean, not only does that create a monumental amount of like extra burden on the attorney in terms of repeatedly having to check in on something that before they would know absolutely, like, it's filed with the clerk's office, here's the file, stamped order, I can send a copy of it to my client so that they can like keep it on them when they're, driving or wherever they might be. And now that's just, unknown, and, maybe client gets picked up because that hasn't gone through in a timely fashion. I mean, that's a real issue. If and the ex parte issue is a huge issue. Like, I think that's one of those things where I feel like anytime there's an ex parte, concern about communications between one party and a judge, a lot of times those are downplayed, because I've had that come up in cases in the past, outside of eCourts. It's like, well, is that really that important? It's like, yeah, it's pretty damn important. Yeah. Like, that's a big deal. So, again, it's not even to say that there's, anything meaningful being communicated, but where there's the opportunity for that, and there's no mechanism for holding accountable or being able to kind of see what, if any, communications have been sent, that to me is a real area of concern. In terms of that, like that queue and where things are going, there are certain counties that I practice in where there's, one DA in the county, like that is the DA, and that, that there's, that's the person you talk to. And like you said, like they're in court all day long. Like they're probably not very, very much able to track anything that's coming in that's not on the docket for that particular day. They're not checking their emails except maybe over a lunch break or something along those lines. But in other counties, there's quite a few DAs. Buncombe, we have a pretty healthy, DA's office in terms of size. Has there been any attempt that you're aware of in these like pilot counties to have like certain DAs that are almost assigned to like just responding to eCourts? Because I would imagine there's a ton of stuff coming through there that would almost like mandate like somebody on their staff that's responding to these things, because that seems like just such a, in Wake County, I just can't imagine the amount of like motions that are getting filed through eCourts. Like it's got to be almost like a astronomical amount of things to respond to. Is there any movement on that front that you're aware of?
No. You just have to basically deal with the DA in the courtroom, just like we always have done, right? But it's even harder now to get a hold of people outside of court because they're, if they're in their offices, they're definitely not answering their phones.
Yeah.
If they are, if they're checking their emails on their lunch break, you might get a one-liner back, if you're lucky. But a lot of times they just go until you pester somebody to death. And obviously that's not what you want to do. Like you want to be able to have like a good relationship with the DAs, but the workload is so overwhelming for everybody. DAs are working until 7, 8 o'clock at night. Clerks are using astronomical amounts of overtime hours, like 8,000 overtime hours have been clocked by our local clerk's office since we went live. And that's been just to keep up with the filings. The overtime is about to end, the unlimited overtime. And so we're going to really see when that happens, what the true nature and character of this program is and our ability to function on a normal, 8:30 to 5 work schedule. And I think that it's going to be a real struggle.
Yeah. I mean, I think if you're already operating at 65% capacity and not really including like all of the kind of non-important or not prioritized issues that are probably again getting pushed to the bottom of the barrel, and then you throw on top of that like additional lack of resources, it's going to be a pretty painful situation. I know that, the DAs, at least in some of these counties or maybe select DAs kind of went through a training model for using this software. I would assume that just like defense attorneys can kind of sign in and play around with this, the DA's offices can as well. And if you have, Lindsey, maybe, I don't know if you would suggest this, but if you're in a county where you have, a larger DA's office where there might be somebody that has, some more administrative oversight, is that something that you would think would be a good, place to maybe go talk to them about, hey, do you have any plan for this coming down the pike? Are you aware of like some of, how much are you aware of the issues that are going on, excuse me, in those pilot counties?
Yeah, I think absolutely in whatever county you're in, find somebody in the defense bar that they absolutely need to have defense bar feedback, because there are still so many processes that are evolving as we move through this whole thing. They're not set in stone. Things that we're having to adapt and try to overcome and find workarounds for, this problem that crops up today or that problem that we had last week, right? So you need to get involved now at your local level to try to engage in conversation with the powers that be in your courthouse. And when I say the powers that be, I mean, talk to your head clerk of court, talk to your DA, talk to your chief resident superior court judge, your chief resident district court judge. All of those people are going to be involved on some sort of implementation team that is currently existing. Okay. I wasn't brought into our Wake County meetings until like last September is when I was invited to start attending, and our weekly implementation team meetings, contains all of those people plus like, our public defender here. We also have, a couple of members of the DA's staff or a couple other clerks, key clerks that are kind of supervisory clerks within the office. We have the TCAs are in the meetings, and we're talking about, all of the different aspects of this, both on the criminal and civil side of things. And so I don't want to say like it's all doom and gloom. It is the civil side seems to be functioning somewhat as intended. The volume is not the same over in civil though. So it is something where they're able to, kind of maintain things. There's been a lot of challenges, they've had to overcome as far as like, like involuntary commitment kind of cases, which is a very paper intensive process. And for those that aren't aware, when you have eCourts come to your location, judges are no longer allowed to do wet signatures. Okay. And when I say wet signatures, I mean, you take a pen and you write on a piece of paper. They have to do the electronic signature. That is required of them. That is a new rule. That is a new law that is in place that says that they have to do that. So in order to comply with that, that creates a whole other set of issues when you have like a very paper driven type of practice. It's not just a matter of the judge, like, let's just sign on the thing and then just scan it into the system once it's in order. It's very much that has to be scanned in. The judge has to electronically affix their signature, and, then that will ultimately be sent back to the clerk and tasked to them to finish things out. But the civil side is doing okay. The criminal side is where this is really the bulk of the issues are occurring.
Hey, podcast listeners, I want to briefly interrupt today's episode to invite you to join me at the inaugural Freedom Fighter Summit in Asheville this October. This in-person only event is designed for growth-minded lawyers determined to take their criminal defense practice to the next level. Due to the size of the summit's venue, there are a limited number of seats available. Don't miss out on the incredible lineup of speakers and spectacular networking opportunity that this summit provides. For more details, visit www.miniclaw.com/summit. Enter the promo code NCDWIGUY, all lowercase, all one word, at checkout for $150 off your summit ticket. Look forward to seeing you there. Now back to the show. In terms of any other kind of prep steps, I know that, when we talked at the convention, you had mentioned that, there's, you've seen people that have really kind of been in this quandary of like, do I even continue practicing given some of the like struggles that are coming up through this? Do you have any other, thoughts in terms of, being prepared for this coming to your county, or if you are in one of these 4 pilot counties, or you're in one of the, kind of next wave of counties that will be taking this on, ways to really have like a meaningful position of advocacy. Cause I really do think like you've created a tremendous amount of like positive change. Again, didn't really necessarily like asked to be in this position, but you're in the situation where to some extent you're representing, not just being on this implementation board with Wake, but kind of representing the entire state, because it's like this is where all of these fixes are coming down. So in terms of like that leadership side of things, do you have any other kind of practical tips in terms of what we can be doing getting ready for this?
Yeah, I think that the really important takeaway is, I know that as a general rule, criminal defense attorneys, we're like really difficult to herd cats. And so, getting everybody to be on the same page, because let's face it, most of us are kind of like little mavericks, and we kind of like do our own thing. And, we want to make sure that, our clients are taken care of. But I think this is a really great opportunity for the defense bar to band together and to try to work as a team to effectuate change within your local community and try to have an impact and try to have a voice in this process. The reason it is so incredibly, I know that like even here in Wake County, historically speaking, our defense bar is the Wake County Academy of Criminal Trial Lawyers. We call ourselves the WCACTL. It's an absolutely mouthful. It's a total mouthful. But we have historically not had a seat at the table when it comes to decisions that are being made in the courthouse. So that's why it was so incredibly important for when, as the president of WCACTL, I was invited to be able to attend these meetings, that we participate, that we show up, that we act respectfully. At the end of the day, what I've seen is that the people that they respond best to at AOC and Tyler and within the powers that be are the people that are going to be working respectfully with them and trying to effectuate positive change. I don't want to sit on here and just basically say, this program sucks. It really has made a huge, horrific impact on my practice, even though it kind of has. But the fact remains that I want, if we have any shot at all of trying to improve the system, we have to do so in a respectful manner. And I can tell you that the people that just yell and scream at the AOC folks are not getting anything done. You need to be willing to work with them. You need to be willing to voice your concerns in a respectful manner and advocate for your clients and for yourselves. So that is what I would say, band together with your fellow criminal defense lawyers, have a sit down meeting with your powers that be in your courthouse, talk honestly and openly about the concerns that you have about this, eCourts coming to your local community, and try to find ways and ask them, how can we get involved? How can we help? How can we give you feedback? What can we do to help the process? And I think that will go a long way towards not only improving your defense bar's standing within the community, within the local courthouse community, but it will also go a long ways because the burden that is put on the implementation committee is significant. I mean, the emails, the meetings, the times that they have to take away, this is all stuff that they're doing on top of their already full dockets that they've got. So anything that you can do to try to either help lighten the load or to provide a valuable perspective, because I can tell you that the criminal defense bar perspective is absolutely 100% needed in these meetings. And anything that you can do to get involved and try to do that is worthwhile, in my opinion.
Yeah, that is awesome. I think that it's so easy to, sit around, in your office or with a group of other defense lawyers in your bar and just complain about the circumstances, right? And rightfully so. I mean, I don't think that there's a reason to say that in a lot of ways is not justified. But I love your point of basically like to have the impact that you're going to need to make your job easier, to do a better service to your clients. Ultimately, probably to have, the lives of the clerks and DAs in your local jurisdiction be made easier, because the better this system works, the better it is for everybody involved. Having a voice at the table that is, raising the concerns, barriers of entry, the hurdles that are in place. I think that is super important. And, I think maybe this is a good place to end, because I think that you have really had, despite being in the position of kind of dealing with being the contact point for all of this, carrying on your practice, representing clients, you have an incredibly positive attitude. And so I don't know if you could maybe just kind of like speak to that for a couple of minutes about like how you maintain that, because obviously there's a lot of fires going on around. And so, what is the magic that you're finding in terms of being able to kind of maintain that positive focus?
I think that one of the earliest things that I learned about being a criminal defense attorney is that you just have to take each new day as its own day and shake off yesterday and whatever bad things happened yesterday. Because let's face it, if you're not if you're not making somebody mad at least once a day, you're probably not doing your job right.
That's
right. But that's not a good way to put it. But the point is that I learned very early on that I need to take each day as its own day and treat it like it's a fresh start and just shake off everything else and go from there. I also am a big believer in, right. I want to make sure that my office space is like a safe office space for when people come back to it from court. Like, I know that this is something we've had to deal with internally, is that, it's been such a stressful time at court. It took way longer than it should have, or we had this crappy thing happen, or the DAs aren't offering us this or that. I think it's really important to give attorneys the space to vent and be able to get it off their chest, because they need to have that safety of expressing themselves, and just being able to get out there. And once I get it off my chest, I'm usually good, right? Like, I might need to say it a couple times, and certainly my husband's going to hear about it tonight, but like, so he'll listen to me and he'll just shake it off too. But the thing is, like, we need to find ways to be able to express yourselves, to vent, to get it out there, but don't dwell on the really negative aspects of it. Like, take it for a learning opportunity. What did I learn yesterday about this? How can I apply that today to make it a new thing that will be better this next time, that I won't have to go through this 5-step process that I can now do, hopefully, in maybe 2 steps. Trying to find little ways to increase your efficiencies, and finding ways to, if you're not a tech savvy person, and I'll be quite honest, like, I'm not a super tech savvy person. I know enough to probably get myself in trouble. But I surround myself, but the other thing is I surround myself, or at least I try to surround myself with people who can fill in the gaps where I have those, where I'm lacking. And this is one thing why I'm seeing right now, we're seeing a couple of older defense attorneys who've been at this for many years saying, you know what, I'm just going to hang up the towel and I'm just going to, get out of practicing, because now seems like a good time. I really don't want to have to learn this new system. But for those of us who are not in the position where we can retire immediately, we have to find ways to deal with it. And, again, try to find ways, things that make you happy, things that do you good internally, whether that's, going to church and singing in a praise band, or whether that's, going to like one of those wine and paint things and painting, which you can see my stuff on the wall that I enjoy that clearly. If it's gardening, if that's your thing, whatever it is, find the things that you love to do and do them, because that is going to be what, whenever you need to take a break from this, and you do, because it is so overwhelming and it's taking longer. I'm working harder than I've ever worked in my 15 years of practice, because I can't get the stuff done during the day that I need to get done. So I'm working at night too, but find time in the midst of everything that you have going on, find time to do things to help yourself and to keep your mental health where it needs to be. Go see a therapist. That's awesome. Do that too. Whatever, do all of the above, whatever it is that makes you happy and can help you find that center to keep yourself, sane in the middle of all of the insanity going on around us.
Yeah, I think that's so important, and I think it's what's made your leadership on this issue so valuable, because there is a lot of kind of difficult news that you have to, share regularly about the state of eCourts and pain points and, just the, personnel, non-communication, not being able to kind of get some of these changes even heard by the right. I mean, it just seems like one thing after the other. And yet you still kind of like convey through your messaging, this positive, like, here's how we're working through this. It's not like, okay, let's throw in the towel. It's always like, here's what, I'm working on here, here's what you can be doing, send your complaints and concerns to this particular person, talk to your bar, go get involved in learning this software. So I really think that positive attitude is such a real credit to your leadership on this front, because it really has, I think, taken a pretty gloomy and dark situation and made it something that is actionable, something that, can be rallied around. So I very much appreciate your leadership on that front, Lindsey.
Thank you. I appreciate that.
Well, thank you so much for coming on. I mean, I know in the midst of again working the craziest days in your career, this is like just one more hour. So again, I really appreciate you helping us kind of confront this issue of being the leader on this issue. So thank you very much. I know you are incredibly busy, so I appreciate you taking the time to talk to me about it.
Absolutely. And I just want to convey that if anybody has any questions, I'm still open to that. I still encourage people to contact me, or to contact like your local point of contacts. I'm happy to do this. I'm very fortunate that I'm in a situation where I have, I'm not a solo practitioner, and I know the time, but I have been, and I know the time constraints that, when you're a solo and not a lot of staff and it's me, myself, and I'm in a situation where I have a firm and I have some staff that can afford me the opportunity to do this. And so it's my pleasure to serve our bar in this way and try to raise the issues and awareness for everybody. And I do encourage people to contact me, and I'm happy to, certainly give out my email address. It's Lindsey at granadoslaw.com. That's Lindsey, Lindsey at granadoslaw.com. I'm happy to answer any questions or try to point people in the right direction wherever they can.
Yeah, no, thank you so much, Lindsey. You're the right person to be pushing on this front. And yeah, I mean, just incredible communication, awesome leadership. Thank you so much.
Thank you. Have a good day.
Yeah, you too. Thanks, Lindsey. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you're listening on, I would greatly appreciate it.